Hi, everybody. It's Mary Jane with Southern California Escrow. We've already been chatting behind the scenes here. I'm so happy to see all my favorite people and the faces that I've missed over the last few weeks while we took some time off for spring break. We're going to have Samantha Mann Hayes talking. Mann, do you even use Mann anymore? Samantha Hayes talking to us about cancellations today. It's a very important subject. You definitely need to know when you are the canceling party and when you are not the canceling party, besides the mechanics of it. We have Tommy Dutcher with California Tile, and we're happy to have him with us today. One of our new favorite things is the attorney tip of the week. And for that, we have a state attorney and a real estate attorney and Andrew Werheim with us. And Andrew, if you would kick it to Sam when you're done, then we'd be ready to get started.
You bet, MJ. Hey, very nice to see everybody. My name is Andrew Wertheim. I own Pacific Estate Planning. I'm a trust and estates attorney, a business law attorney, and I can help with a variety of real property work as well, either myself personally or I have several colleagues I work with. Today's tip of the day, I want to talk about deeds. I regularly am representing the seller either through a probate proceeding or a trust administration proceeding. And 3 times over the past month, none of which was Mary Jane or Tommy involved in these particular transactions, because I know that they know better. They are true professionals. But 3 separate times representing the seller, and I'm noticing that the escrow company and the title company is allowing the buyer to take title just in their names. So not husband and wife, not joint tenancy, not community property with right of survivorship, nothing. It would be as if we had a married couple and their names are Jim and Carol, and all the deed says we're granting to Jim and Carol. And that's it. And that's a major problem for my set of blinders, because I know if Jim or Carol passes away, that the default is tenants in common, which means that 50% of the house, if one of them passes away, we don't exactly know who that goes to. There's no right of survivorship. So we'll have to file a court action and go ahead and determine that. And it may not be the surviving spouse, which could lead to all sorts of problems. You know, who pays the utilities, who's paying rent to whom, et cetera. Certainly increases my customer base and my workload, but I'd rather do it with happy things than unhappy preventable things. So if you're ever representing a buyer, first, please get Mary Jane and Tommy involved, because they do know better than these other companies do. And second, if you'd like to get me involved, I recommend before the buyer purchases the property, have them call me. No charge for that call. I'm happy to explain what the difference is between joint tenancy or community property or right of survivorship or not, and we'll give them some good guidance. So that is this week's tip of the day. Please stay tuned. I'll be going in more detail on how ownership property is in my next presentation. We'll go spend about an hour on that topic. But for now, I'm very excited to hear from Samantha, and I'm going to pass it on to you. Thank you.
Thank you so much for kind words and getting stuff started. And I completely agree, coming from a TC point of view, the more information you can get over right away, definitely it's great to have somebody who can answer those questions. So I'm going to share my screen and get started here about the cancellation contract. I'm Sam Hayes. I've been TC for 19 years this month, done over 6,700 transactions. I'm a car forms trainer, wind forms trainer. I'm a big nerd. I love this stuff. So I'm here to talk to you about the different forms and such. I cannot give legal counsel. All I can do is talk to you about the forms. You always want to get your broker of record involved in any of these type of situations, and we'll go from there. Thank you to Tommy and MJ for having me on as always. And I do love this stuff. So I will happily talk about forms. There's no cost or issue whatsoever anytime, even if I'm not TC on the file. I'd rather we got it straight and everybody had a good business model. Cancellation of contracts. How do you get here? Well, the biggest part is going to be in the RPA. It's section 14 and time periods and cancellation rights. This is a breakdown of how does it begin. So most issues that have been coming up lately is a lot of sellers are deciding they just want to cancel. And that's not how that works. And it's much easier for the buyer to cancel because California law tends to protect the tenant or the buyer over the seller. When you're going through a cancellation process, it's a lot about details and due diligence. So we're going to go through all these sections of the contract real quick so that you can see why it's such a big deal and why the different steps lead up to how and what you can cancel based on. Starts off with the seller needs to actually do their portion. They need to deliver all the documents. They need to deliver everything within a time frame. If they don't, that's going to extend when the buyer has the opportunity to review items and delay notice to perform and cancellation. In a typical, nothing's been changed, basic contract, seller's got 7 days to deliver your disclosures, any reports on file, should be also the HOAs, but we know that can take a little bit longer. Anything of material fact that they are aware of. The buyer then has 17 days to do their investigations, go to the property, review the documentation, make sure they're aware of everything before their contingencies are due. Within this time frame, requests for repairs can be negotiated. Everything can be discussed. If there's any change in price, if you're dealing with an appraisal issue, this is the window to kind of, everybody still has a little bit of an out clause because you can use your contingency for your investigations. And it's considered that if the seller is not officially canceled and there's not been a notice to perform, that contingency continues on. It is an in writing situation in the state of California per the CAR contracts. This is making sure you've had access to the property and everything else along those lines. Once that's all done, what if you've had somebody remove their contingencies with the offer and then they want to cancel? Well, it depends on what contingencies they removed. And if this box is marked and you've removed your contingencies, you're going to have to be very specific and very careful about what reasons. Did you get new material fact that wasn't provided? Did you get new information? That's when you're going to talk to somebody of a legal level and get your broker involved, because things can get into negotiation issues and gray areas, and without having all of the facts and your time frames. Also why it's so important to communicate everything via email in writing so that you have time date stamps for your documentation. Because remember, now in this contract, now the revision that came out in 2021, once something's emailed based off the email address that you have on RPA 16, that's considered delivered and that starts your clock. The seller has to go through a few steps before they are able to cancel the contract. If they have completed all of their contractual requirements within the contractual timeframes, then what they need to do is do a notice to perform. Now, the notice to perform we'll get to next and show you the form itself, but that step comes first. If all contingencies have been removed and the seller has a delaying buyer, you can also do a demand to close escrow. We'll also discuss that in a moment. The seller first delivers the notice to perform. Now, what happens a lot of times is right here, people, if you don't read your contract when you're getting an offer on the listing side, this number can change and different assumptions are made. If you provide a notice to perform to a buyer without the correct timeframes, because you can do it up to 48 hours before it's due. So say your contingency removal was due on day 17, that falls on our basic weekday, Monday, Tuesday, Wednesday, Thursday, Friday. There are no holidays involved. You could then notice 48 hours prior to that. You cannot give a notice to perform earlier than it is that amount of time that it's due. You also can't shorten the time frames. So if this is what was contractually agreed to, that you have 2 days to remove that, you have that notice, then it needs to be provided in that time frame. You can't suddenly make it 24 hours. You can't decide it's 5 o'clock on tomorrow. It's got to stay within your contractual time frames. So the demand to close escrow could be when you have a buyer who is delaying, there's something going on with the loan, money may not have come in, travel, many reasons. That's when you would do a demand to close escrow, which this is a 3-day notice. And again, you can only notice this 3 days prior to the scheduled close of escrow for the demand. It also needs to be on a regular work day, a Monday through Friday. Weekends and holidays do not count for, you can't demand performance on those per RPA 30F. Now, what happens if you do all these things right and you're going to go ahead and cancel? And what do you do about the deposit, but the other side won't sign? Because cancellation takes somebody to initiate the cancellation, and then the release of the deposit takes agreement of both parties. Well, what you can do is notice to escrow, and they have 10 days to go through, and you can send over the buyer demand to release the deposit or the seller demand to release the deposit, depending on your situation, what's going on. If within 10 days, for some reason, you've got a party that disappeared or they're just not contesting it any longer, they then can release the deposit after being served this notice from whoever is trying to hold on to things. Please note, and a lot of times it helps remind a buyer or seller who's in an emotional response time frame, because buying a house is a very emotional thing. And sometimes people aren't paying attention as much. You can always remind them that there is up to $1,000 penalty, civil penalty for refusal to sign cancellation if no good faith dispute exists as to who is entitled to the deposited funds. That typically gets everybody to kind of start playing ball, but it's something to remind them of. So going back to that, when can we send these notices? Well, the contract luckily clarifies for us specifically definitions. So days are calendar days. The only thing that is not calendar days is your deposit for when that's due. But you can't demand performance on a weekend or a holiday. It has to be the next business day. It also specifies how many days prior to, meaning calendar days prior to. So if your contingency removal is due on Monday, you can send the notice to perform on Saturday morning, because you're not demanding your performance until Monday. Or you can send your demand to close escrow. If you're supposed to close Monday, you can send it on Friday to get your clock started. But again, the action of starting versus the action of demand when the action has to be performed. And delivery at this point is personal receipt for everyone. This is on the older contract, but it doesn't matter anymore. It is now directly whatever information you put on page 16 is considered personal receipt. That's why it's so important to have the most up-to-date emails for both the buyer and the seller's agent on page 16 of the contract. So timeframes. Well, what did you have in the contract? As we looked before, you've got to make sure you're paying attention to, was something adjusted in the contract you received? Are you making sure that you're on top of it and getting all the information and staying within your timeframes? Is it a contingency or contractual action? You actually can notice perform for both. People forget that sometimes. And do you have a cooperating where they have to get a replacement property, or the seller actually is trying to find a replacement property? Now, with the seller trying to find a replacement property, as long as the SPRP is included in the transaction, that is the only time the seller has contingencies in the contract. One is to locate their replacement property. The other one is the ability to close. So you need to review those documents to see how they come into play for sorting this out. The days you can demand performance, we just reviewed that. And what are your next steps? So the notice to perform has two sections. We have contingencies, and you can do individual contingencies. You can do all contingencies. And if you have a specific unique contingency to your transaction, one, I would have your broker review that transaction before it was accepted. But two, then you would go into section J or K. The other thing you can do a notice to perform on is contractual action. That's your deposit, that's returning your disclosures. That is also, fun fact, the RCSD, you are supposed to, per RPA 28, provide signing authority documentation. This is something that people forget, that really is required within 3 days of acceptance from the party signing on behalf of the entity and to escrow. Not escrow sends it out or escrow has it on file. That's not escrow's responsibility. It is the responsibility of the party per contract to deliver this. And it's an opportunity, if you're not paying attention to it, that if somebody wants an out, this can be an out of the contract. Also, delivery of your pre-qualification if you're signing the contract, because remember, that's now a time frame situation in our contingencies. Verification of funds, all the things. So you're going to also prove that you did go into escrow per your COP if you said that's what you're going to do to be able to buy this property, creating chain situation, or same for a seller that they found their replacement property. What is not on here that becomes a big deal is request for repairs. The request for repairs is not a contractual action, nor is it a contingency of the contract. Request for repairs is, seller doesn't even have to acknowledge nor respond to it whatsoever. It's just an ability that the buyer is allowed within the contingency timeframe to make requests for repairs. They can ask for the moon. The seller doesn't even have to respond. So that's something to keep in mind, because people tend to hold off saying, well, we're not removing contingencies until the request for repairs are responded to. They're two separate issues. You'll need to talk to your broker and see what is the best way to handle the situation you're in on each individual transaction. We've removed all contingencies, but we're still not closing escrow. What do you do? Well, then it's time to do a demand to close escrow. This one is the 3-day one. And again, you typically don't do a demand to close escrow until you've already established you've done notice to perform or all contingencies are removed. Now, in this form, there are 2 sections. The buyer and the seller can demand the other party to close escrow. And what you're going to do is it's 3 days. You can say you've agreed you're going to give them 7 days, but it can't be any earlier than when it was agreed to contractually for the close of escrow. So you're going to again go back and review page 1 of the RPA. When did you agree? You can only deliver this 3 days prior to that. And there's 2 sections. The form's the same, but I just wanted you to see the verbiage that you can pick A or B, but you use the same form. It doesn't matter which side does it. Okay, so we've gone through all of that. We've gone through all these steps, all these layers. How do we cancel the contract? What do you do? Well, there's 2 parts of the form, and that's a big issue because that gets missed a lot. This form actually does 2 things. It cancels your contract, but it also releases your deposit. And that piece gets missed, and that can cause delays. So you're going to want to make sure that you're paying attention to that when you're reviewing your documents. So our first section, this is the cancellation, and this is the top portion of page 1 of this document. You're going to select if it's buyer or seller or both. This is you're going to want to be very careful about this and discuss it with your broker. Both, sometimes if it's a contingent situation, a lot of times the sellers won't sign because they don't agree to the cancellation, and then you have to start all over. And I have had these situations where we had things that went to court or there were issues, and if we didn't have it filled out properly, we didn't have a leg to stand on. You're also going to want to make sure that it's as permitted by good faith exercise of paragraphs. The whole reason you have the different contingencies in the contract is the ability for the client to remove or to cancel the contract if they need. You're going to want to stay as close to a contractual reason for removing or for canceling the contract. Again, you're going to want to discuss this with your broker of record on your specific transaction. However, citing a family issue or a personal emergency or something that's non-contract based, you're going to be opening yourself up to a lot of debate and discussion, especially if it's not something that is about the contract. And is the buyer then acting in good faith if they're just taking off because they've lost? I mean, if they've lost their job, then of course they can't get the loan. You'd be better off saying the loan contingency clearly than discussing that they lost their job. You want to stay with contractual items and review everything with your broker. You also can note when you've been noticed to perform on either side, or you've been given a demand to close escrow. Sometimes everybody just decides this isn't working and it's mutual agreement. That one, I, again, would be very cautious to use. And also the same for other, I'd also be very cautious to use. You want to utilize as much that's already written in the RPA because that's why it's gone through by CAR. So you have the protections of using CAR forms.
I'm going to jump in here, Sam, before you run off.
Yep.
That's okay. Yeah, I back you up one. The signature lines here are not here, but there are only one set of signature lines. There is only one canceling party, the seller or the buyer. So whether you want, so some people want to make it nice or want to make it like it's not disagreeable or annoying to both parties, and they will mark the boxes that both buyer and seller cancels or by mutual agreement, but only one person signing the cancellation. One person cancels, one side of the transaction cancels. There's an official canceling party. And one of the things I wanted to mention here is if you're not in the position where you should be canceling, for instance, a seller, and you haven't finished your duties that you were supposed to do, whether or not the contingencies are available, if you have not turned in the HOA docs, if you've not dotted your I's and crossed your T's and you cancel that escrow, the implications shift in risk and responsibility to the canceling party. The other thing that I explain over and over again every year, all year long, is once a cancellation's been issued, even if the bottom hasn't been signed by both parties where you would do the deposit, which I know Sam's heading for to cancel the escrow and deal with the deposit, this escrow is canceled. So people say, well, my client's not going to sign it. I don't care whether your client signs or not. He just won't get his deposit back, or he's not cooperating with me and helping to get the deposit. So it doesn't, the canceling party is a very important thing. So one of the things when she's mentioning you should speak to your broker before, if you're not absolutely positive, you should not wait for the other side to write the cancellation and be the responsible party. There are times as a broker where I will actually instruct you to not write the cancellation and hold for the other side to do it. The other quick thing I wanted to go over was conflicting instructions. One side feels very strongly that they were right, and the other side feels just as strongly they were right, and they will both write cancellations and fire them off to each other, which is just documentation of a conflicting instruction, which means it can't be followed. So the only benefit that comes out of that is we have written proof that we're at a full stop because both sides have written a cancellation. It's unless the instructions are mutual, neither party's cancellation can be used. So rewriting a cancellation because you didn't like the phrasing or you think that your cancellation is going to top theirs is not correct. You definitely have to be mutual or nothing can be done. But and then my final thought is, and while Sam is very careful not to do those things, I've been a practicing broker so long I can't help it. That we really ask you to try to stay to paragraph 14 as much as you possibly can for cancellations. If there's any time left for anything, when we used to have the car certification classes live, when Neil Kalin, the lead car attorney, said to use paragraph 14 and that you don't really want to know why we canceled, a lot of people popped right out of their chairs because they're people at our level who are going to take a car certification class and they think they do want to know. But you should say as little as possible when you're canceling about why. No matter what you know or whether your agent is your best friend sitting at the next desk, it is just the most I will instruct an agent to say is, I don't know, it looks like they got cold feet. That is the most I will say about it. We should be very careful when we're giving any reasons for cancellations other than what you've written here, and then still be very careful about what you wrote here. So thank you, Sam. I just wanted to mention the one signature lines mostly.
Definitely. Well, and the other thing is you don't have to, the buyer or whoever's canceling does not have to give a reason. I mean, since it's typically a buyer canceling, I'm going to say buyer, but again, they do not have to give a reason, and people will hound and hound. They do have to hand over any inspections that they have done during the transaction. If you cancel, you cannot charge the seller for those, because I've run into that situation where the buyer feels they should be reimbursed for their time, and that's in the cart. I think it's RPA 10.4, I think. I'd have to double check. But I do know it's in there. So that's also an issue too, is it's not up for discussion. If they want to cancel, they're within all the timeframes, all the documents are there, they get to cancel and just move on and be ready for the next one. I know in this market, it's not as big a deal, but we will be at some point in markets again, where it is an issue. And we need to remember, don't have the conversation, less words, too many words. The whole reason, part of why the RPA has been revised the way it has, with section 3 being such, just kind of check the boxes. Anytime we add anything to the contract, you are practicing law. You are changing the terms of the contract.
The other party will often think because they didn't sign the cancellation, which is the bottom half, which she's about to go over, where we're going to deal with the deposit, because they didn't sign that, the other party cannot continue going on with their life. But once it's canceled, they are able to take another offer. They can go into another escrow. They can continue this argument with you for as long as it takes and go on with their life. So refusing to sign a cancellation is not a legitimate, once you've been served one. In fact, one of the things I teach as a broker all the time, when people are hedging right down to the last minute for something very important, I'll say, okay, but don't push far enough to get the cancellation, because you're gonna wind up having to uncancel. Which is possible with a single couple of sentences. We can all agree to go back into contract and pick up where we left off. But once the cancellation is served, there's no obligation to take you back, none. So don't tell your spouse you're moving out unless you really are, because there's no obligation to take you back.
Well, especially now with the new delivery, where it's once it's sent over, that's personal receipt. We're not waiting for acknowledgement. We're not waiting. Once you push that go button, it's delivered.
That's why it matters so much who signs the top. So, because that's the party who's taking responsibility for the cancellation, and they better be on the right side of it. Sorry, Sam. Thank you.
No, nothing to be sorry about. I appreciate it. Just more brains, better. So this is about where you're going into releasing your deposit. So one of the things is you're going to need to put in as much detail as in the escrow number and the escrow company. And so this is one that comes up a lot of times where, well, buyer didn't pay anything. Why should the buyer have to do that? Well, if you've agreed in the contract, the buyer's paying for the HOA documents, then they're going to be less that deposit for those HOA documents. Or if anything's already been incurred to be paid for, if they said they were paying the termite and that's already come through, that can be an issue too. You can also say, okay, we're going to give up half the deposit, whatever was agreed to there. You can go ahead and also say we're partially releasing, but we're still retaining our rights to debate this. So there's definitely different ways on this form that you can move forward. You can release part of it. Again, you're going to want a broker to look this over with you because this is a potential for going into litigation. This is a big deal. And this is also making sure you can move forward to your next transaction if you're on the list side, or that buyer gets that money back so you can get it into escrow on your next offer. You're going to want to make sure you do it right, and you do it right the first time with as much clear communication, but don't add too many words is the best way I can explain it.
Very rarely is escrow going to charge you a cancellation fee because realtors are our clients and we hope you'll be back, and we aren't trying to penalize anybody. But occasionally an escrow has taken itself to a limit that is beyond regular work, and an escrow company will approach you for a cancellation fee. If they do that, they usually have excellent reason, like they've ordered 7 liens and they've been in escrow 90 days and they've spoken to everybody under the sun every day for the same amount of time. So it's usually that the transaction is well beyond any sort of normal work that at that point you may incur a cancellation from an escrow company. It's rare, but it is possible.
And with that, let me know if there's any questions. I will talk about the stuff till I'm blue in the face. Again, I cannot give legal advice, but I can advise on the forms and what I've seen in my own personal experiences. I will always redirect you to the broker of record to make sure you're covered. But I'm happy to talk about it. I do have my own little Facebook group that I put up tips and tricks and different videos and things that I make as well throughout the month. And I'm here and happy to help anytime I can. So I'm going to stop my sharing. I did
Sam,
add.
Sam, is that identical process for a seller canceling a buyer, minus, obviously checking the box, seller is the one issuing it, right?
Yes.
Just
But you
seeing
only,
a
the
lot
seller
of,
really, the
seen a
seller
lot of
has,
stuff lately where buyers are presenting offers that are just making it sound like it's extremely great offer, right? But then wanting to take it amongst themselves, I guess, to not abide by those terms or change the terms, and comes down to the last minute and different things happen. And, sellers are being put in a situation now where the original contracts that were written really aren't even in play anymore, meaning the terms.
so that's why you have to do the notice to perform, where you do the notice to buyer perform. And that's why you don't just have the contingencies to notice somebody to perform on. You also have the contractual action, supporting documents if you're signing on behalf of an entity, proof that of your funds, verification of down payment. So many people don't include that anymore. And the thing is, that is technically supposed to be over, and it needs to be verified that somebody made sure you have whatever amount to make this down payment. And if it's coming suddenly, you're doing a hard money loan, I don't care how you're getting the money. I need to know you've got my deposit. I need proof that you can give me that you can have this other money when we close. You get it any way you need to, but this is what you've told me will happen.
And let me just hit on this too, because I took a note of what you said when you were leading into the timeframes. From a seller's perspective, if a seller is canceling the buyer, if all contingencies have been released, then it's a demand to close, not a 3-day to perform.
So notice to perform is 2 days, typically, unless somebody is, as I showed you, can change it in the contract. It defaults to 2 days, and then demand to close escrow defaults to 3 days. And
right. No, I guess my question would be is if all contingencies were removed and they are up to 3 days before closing, do they have to issue the demand to perform, or can they just automatically go to a demand to close?
They're done with the demand to perform because everything's considered removed unless there is
Gotcha.
something outstanding that was a contractual action.
No
Typically,
longer, let's be very clear, you can no longer use a notice to perform after all contingencies are
Right.
removed. Your last
Okay.
remaining right is the demand.
demand to close.
And I asked that question. I knew the answer because MJ and I have had this conversation many times. But I asked this question because I hear this question come up on the regular. So I wanted to make sure that that was discussed in this for anybody who's listening or watching.
We had one more date addition this year as well that many of us forget because it doesn't come up very often. A recorder's holiday will also be a benefit to the buyer if necessary. So if their performance day falls on Cesar Chavez Day and the rest of the world's open, but the county recorder's closed, they do get the benefit of that additional day. So if that happens to be on a Friday, they're going all the way to Monday. So on timeframes, CAR has been very careful to try to keep it coloring between the lines so that you're not thinking out of the box too much, but there is a recorder's holiday exception as well now.
Yeah, is that for just the demand? Because you could still remove contingencies. If the recorder's closed, that doesn't have anything to do with your loan typically,
No.
like,
For demand to close.
yeah, it's only demand close because you can't, it's a business day, and since that won't be a business day because you cannot close that day since the county recorder's closed, you can't demand the action take place when it just can't happen.
Right. No, and they kind of put that in there because now recorders offices used to follow just the holiday schedule. So if the holiday fell during a work day, it was a holiday, right? If it fell on the weekend, and they just wouldn't get that holiday. Now they issue floating holidays. So if a holiday fell on a Saturday, then more than likely they could say this recorder's office is going to be closed on, say, Friday, or it's going to be closed on Monday to support that holiday. So they've kind of put that terminology out there because of that. But ultimately,
and when I was a young person in real estate, if the recorder's office was closed, so were we. So that's not true anymore.
No, that's not. Well,
They have quality work days now, and they let us work anyway.
Well, and starting around Labor Day, I tend to late August to start reminding people because we get out of practice. I mean, you have 4th of July and you've got Memorial Day, but that's really the only next 2 big ones we've got coming up. And then when you're going from September through February, you've got at least one day that is going to be a legal holiday that you can't do the demand for performance. And especially when you're getting towards the holidays and the end of the year, reminding people to take a look, you've got to pull out a calendar and really look at your contract and when you're aiming to close. And especially with, as Tommy said, this year we'll have 3-day weekends again.
I want to touch on one more thing that's, I think, is very important. One of the things that all the CAR certified trainers were asked to teach this year, and I know that if you took my new RPA class, you heard me say it, that there is no such thing as a non-refundable deposit in real estate either. It can all be liquidated. So CAR has asked us specifically this year to stop writing anything that implies that there's such a thing as a non-refundable deposit. It may be pre-released. It might have even been handed directly to the seller in some unusual situations. I have an investor who won't take a check, won't take anything but the check directly from the client because he doesn't trust the check to clear fast enough. He believes he gets held up 6, 7, 8 days. So he wants to check himself. Very unusual. When I try to do it as an investor, I've never made it work, but somehow he gets them every time. So it doesn't matter how that money passed through that escrow, the buyer or that deal, that buyer has a right to litigate if under the liquidated damages and arbitration clause rules, there is no such thing as a non-refundable deposit. So when an agent calls and tells me that we agreed at the beginning this would be non-refundable, that was a void agreement right out of the gate. It's not, there's no such thing.
Well, isn't it? It's also discussed in the revision of the contract, MJ, and I gotta remember where, but it's specific. There is specific verbiage stating that we are not supposed to talk about whether or not who's going to get the deposit. We have no say in that. We cannot advise on that. That is not up for agents to jump in and you don't tell you, oh yeah, you're totally going to get your deposit back.
It is literally the practice of law, and that's where we're supposed to stay out of the practice of law. Especially when a agent calls me as a broker and tells me that they're positively this, that, or the other, I will tell them they're positively not. We're all gonna be following the same rules. But yes, I wanted to remind you guys that there's no guarantees on deposits. They have to be negotiated. They have to be settled. But I will say this in a positive light. One of the things I tell people when their deposit's stuck is it's not going anywhere. It either has to be a mutual agreement or act of law. That's the only thing that can get a deposit out of escrow, period. Nothing else will get a deposit out of escrow. So yes, you may need it. Yes, you may want it. Yes, it may be a crucial part of your next transaction, but it is safe in the escrow company's hands until it gets settled. That's another big misunderstanding among realtors, is that there's some magic that some button you can push that's going to guarantee the deposit is going to be released on your say, or
Right.
under certain circumstances. That is all prep work leading up to the conversation where you really are going to decide what you're doing. But I just wanted to remind you that CAR asks us to stop saying that the deposit is non-refundable, because it's not true.
Well, the other thing that you're reminding me that I wanted to bring up too was I have a lot of clients will be like, I'm sending a notice to perform. No, you're not. You're not party of the contract. Have you had a conversation with your client? Do they want to cancel? You know, you can
The paragraph Sam was looking for was 5A3, retention of the deposit.
Thank you.
It's our fresh wording in here that says, so there is no such thing as a non-refundable deposit. So, it will be subject to arbitration and liquidated damages. And although we say a lot, speak to your broker, there's a good reason. I'm going to immediately look at liquidated damages. I'm immediately going to look at arbitration. I'm going to see if it got initialed in the right order and whether those people even have the rights they think they have. So cancellations are, the reason I asked Sam to speak on it was not just the technical side, although she always does a beautiful job with that. And she's an amazing practitioner. But she's wise when she says, seek your broker's advice, because he's the person who's going to have to live with your
Decisions.
And
Yeah.
sometimes, like I said, when people call me up and are thinking that anger is going to work on me, as a broker, it's very helpful for me to be able to draw their attention back to the facts. So it's helpful to have your broker involved. Or a really good, smart escrow person.
The other thing about notice of perform is just remember, it is an administrative document. It exists in the transaction for a reason. Just getting one is not this affront to you as you are as a client, of being an agent. It's not a slander against your personal being. What it is they're taking the steps in the contract to follow the correct procedure. And just as you would need to protect yourself and your client, the other side is doing the same. So when it becomes an emotional response and people start to elevate, you need to step back and go, okay, we're talking about something that was outlined in black and white. Both parties have agreed to it. You as an agent are not party to this contract. And you need to step back and calmly, coolly advise. And again, as MJ said, I'm going to keep reiterating because one, I am licensed in a different brokerage than everybody here. So I'm going to tell you, double check with your broker. But two, the broker is ultimately responsible for your actions on the transaction. They need to be aware of something to help mitigate potential litigation.
Even if we think you did it wrong and we have to, as an agent, and we have to tell you as your broker that you did it wrong or whatever, that demonstrates broker supervision.
Yep.
And may be helpful when I'm dealing with Andrew down the road. Somewhere I'm going to be able to show that that I took in the information. I don't know how many times I've had to call a broker and I can't even get them on the phone. So how are they demonstrating broker supervision if I can't even run it by them? So that's another whole can of worms. But I do have notice performance without hurt feelings on deck for this year as well. We did have to finally write it as a humorous class because people, like Sam said, they really do get very hurt that they got a notice to perform. And I remind people all the time that notice to performs are a broom, not a stick. Intended to clean, they're not intended to beat you with. And here's a line for you, by the way, which I taught my agents was, if you will write into your counters that your broker insists on timely service of notice to performs, I tell people all the time, blame me or blame the broker that person's crazy. She wants notice performs every time. You know, I don't want to, but I have to do it. So get used to notice of reforms not being personal.
I do not see any questions in the chat. However, if there are any questions, anyone can feel free to unmute themselves and ask. But MJ, until that may happen, do you want to lead in with what next week's training is?
There's so much good stuff. I think I'm gonna let Andrew pitch next week. Andrew, why don't you tell us about because Andrew's our speaker next week and he brings a higher level. You know, I just reminded him again today that I know he's smarter than me and that degree approves it. And so I think he'll do a better job telling us what next week.
Well, I don't know about that last comment. You're pretty smart, but I am excited to present. And essentially, we're going to go over two things. One, what do all the different forms of title mean? What is the difference between joint tenancy as opposed to community property with right of survivorship? There are huge creditor protections versus tax savings depending on that choice. And I know when I bought my first house, no one told me, and I just took a guess. And now that I see this regularly, I sure wish someone had. And that's the passion behind this this presentation. The other half of it is we have a recent California Supreme Court case that really digs into the difference in various presumptions, because what the deed says does not necessarily control. The deed could be lying to you. There are so many hidden pitfalls in the law that are based in case law and not based in common sense necessarily. And I want to go through those. But essentially, the rules are different so we could have one deed that says one thing, right? And if we're in a bankruptcy proceeding, we'll have a different result than we will if we have a divorce proceeding, than we will if we have a death. Three different roads, I suppose, with three different interpretations, and the same deed will be interpreted three different ways. And I just want to go through that because I really want to encourage, if you are representing a buyer, they have no idea, right, how they take title. And I would love to be there to help guide. So that's what we'll be talking about next week.
I'm excited about that because we're not allowed to advise. We give the little title form that has a basic understanding of the difference between joint tenancy, community property, trusts, and that sort of thing. I personally haven't peeked behind that door. I did not, until Andrew was educating me to prep us for this class. I had no idea that joint tenants meant we could be individually sued and held jointly responsible. So there's, and vice versa, or I know I'm not saying it right, but I just never looked behind that door. This is a very interesting door, and I'm glad we're going to have that recorded to share with others at the time that they're making their vesting decisions.
Yep. All right, so that'll be next week's class, same time, same place, same link, and we've been anticipating this class now for a couple months, so we apologize to Andrew because he was gonna present a few months ago, and then we decided to take a little break with everything that was going on. So we're very excited to have Andrew present this to us, and I would encourage if you're a TC on this today to let your agents know, because from a title perspective, I get this question asked all the time. How should my clients hold title? You know, and I'm not going to tell them how they can hold title because that would be giving legal advice. And I'll hand them a flyer, you know, that has the different ways of holding title, and it gives a very brief description of each one, which can be interpreted, I guess, how you read it. So, you know, and you're not in a situation as an agent to give that advice either of how they should hold, right? So to have somebody like Andrew that they can reach out to that isn't going to charge them to answer that question or explain something, you know, to just tell them the difference between joint tenancy and tenants in common with rights of survivorship or et cetera, is a huge benefit. One, because I've yet to see anybody do that. And two, I'm looking forward to Andrew going in depth of what each of these are, because I think it'll help everybody as an agent understand it a lot better, and not just understand it, but be able to explain to their client, not explain to their client, be able to direct their client in a better direction. Right?
Yeah, we don't want to give any legal
advice.
Yeah, we don't want to give any legal advice, but at least to have a healthy respect for it, to say, look, this is a very complicated issue, and I want you to get the correct advice. So here's a couple numbers. Doesn't have to be my number, right? But just here are a couple of numbers of trust attorneys who can give you that answer.
Correct.
One of the first things they teach you in escrow is to know what you don't know.
Yep.
There has to be a sensation that hits you when you don't know, that's okay, and that there's a space for that. Because I think in our business, we're all prone to problem solving and working off our experience, and sometimes we forget that question might be over our heads. Right. The week after, Andrew, I'm going to teach assignments, and I'm so excited to teach assignments. Every time an agent cancels a deal, it just kills me because we could have assigned it out. So we're going to really be pushing out the assignments class this month as well.
MJ, can I just add something to that? Because a lot of agents don't understand when you say assignments, what it is. Let's give just a quick overview of, if you're in a contract with your buyer and your buyer decides to cancel or walk for whatever reason, you still have an accepted contract with the seller. You could reassign that contract to a potential another buyer as long as the buyer will agree to exactly the terms that are on the original contract. And that's what MJ is going to teach you how to do.
Some minor changes.
Yeah. And that's what MJ is going to teach you how to do is, before you just cancel and walk away, like throw your hands up, like, oh my gosh, all this work for nothing. What are the odds that you or another agent that you may know may have a buyer looking for that type of house at that price point for those terms, right? So that is one that everybody should be a part of next week. It's going to be awesome. And you shouldn't miss it.
We've got so much on deck. I know we're going to wrap up here, but we have so much on deck. We have cannabis in California for real estate. We have a solar at Sam's request, which I have neglected terribly. We have the HUD Homes director on deck to come in and talk to us about HUD Homes, although it feels ridiculous to us right now because it's so hard to get a home that we would still be doing HUD Homes, but they're still out there. The liquidated damages and arbitration class. My favorite thing about these classes is one sort of leads to another. Like the natural following of Sam's class should be arbitration and liquidated damages. It is what it is. Anyway, you guys, we're very grateful to have you. If anybody has questions, we stay on until you guys are all checked out of the class in case you want to speak to us off the record or get our phone number or ask us a particular file situation. Thank you all for being with us, Sam. Thank you for always doing a professional job of giving everybody their choices. I really have enjoyed that they've improved the notice to perform. I think we got 10 new choices, it feels like, on there.
Less revision. Less revision update a lot.
And so it's great, Andrew. We're looking forward to your class, Tommy. Again, thank you all for letting me take a little break. And we're back now, and we'll see you on Monday.